Hello, everyone, and welcome to this webinar on filing a provisional or non-provisional utility patent application. This is the second of our Business Learning Lab winter webinars on intellectual property in partnership with the U.S. Patent and Trademark Office. I'm your moderator, Jenny Alton, from the New York Small Business Development Center Central Office. Today's presenter is Monica Shin, Assistant Outreach Coordinator and Primary Examiner. We also have her colleague, Gautam Ubale, who is also an Assistant Outreach Coordinator and Primary Examiner, to answer questions today. This webinar is brought to you by the New York Small Business Development Center network of 20 campus-based centers and many more outreach offices, which are located across New York State, along with a central office based in Albany. The NYSBDC is a U.S. Small Business Administration resource partner. Our free advising, education, research, and advocacy services are made possible by funding from the SBA, New York State, and our host campuses. So you know, this session is being recorded. We will share it with attendees in the next few days, along with a PDF copy of the slides in a follow-up email. Attendees are muted and will not be on camera. If you have any questions during the presentation, please don't hesitate to type them in the Q&A box as they come up. You can open Zoom's Q&A box from the Q&A button at the bottom of your Zoom window. Gautam will be answering questions through that Q&A box throughout Monica's presentation. To help us keep track of all of your questions and make sure that we get everything answered, we do not have the chat turned on for attendees today. So please make sure that you locate that Q&A box and open it up so that we're able to help you get all of your questions answered during today's presentation. For very specific questions that may take more time and detail to answer, or if we run out of time to answer all questions today, you will be able to get in touch with the USPTO through the contact information that they will share in this presentation. You can also reply to the follow-up email to get further assistance from us at the SBDC. And now I want to turn a few minutes over to my colleague, Liam McMahon, who is a certified business advisor and our technology specialist for our network. He is out of the Binghamton Center. And so I just wanted to allow him a few minutes to be able to tell you about how we assist technology clients here at the NYSBDC. Thank you.
Thanks, Jenny. So as Jenny said, my name is Liam McMahon, and I'm one of the technology and innovation advisors here at the New York Small Business Development Center. The NYSBDC offers a wide range of services for people interested in commercializing their technology, including, but definitely not limited to, helping develop pitch decks, creating and vetting financial models, and frequently helping you connect with other resources, both in New York State and around the country. I generally always tell people, if you need help with something, reach out and ask us. And if we can't find the answer, we will find you the people that can. So if you're not already a client, please don't hesitate to sign up for services, and we can see how we can help you develop your new tech. If you're already a client, feel free to reach out to your advisor, and we can set up a meeting or set up a time to discuss what needs you need fulfilled. So with that, I'll turn it over to the USPTO, and again, don't hesitate to reach out.
Great, thank you. All right, I will go ahead and share my screen. All right. So as Jenny had mentioned, today we'll be talking about how to file a provisional or a non-provisional utility patent application. The objective for today's presentation is to go over the contents of a utility patent application disclosure, learn about the enablement requirement, understand that the limitation of claims can be modified based only on what was disclosed at the time of filing, and the importance of capturing the invention using clear and consistent language throughout the disclosure. Now, there are two types of applications that you can file for a utility application: a provisional application and a non-provisional application. So you have the option of first filing a provisional application, which establishes a filing date for your invention. There are no claims required for a provisional application, and provisional applications are not published and they are not examined. So a provisional application itself will never result in a patent. Now, provisional applications are valid for 1 year. So it essentially gives you 1 year to decide whether or not you want to pursue a non-provisional application on your invention. Now, the non-provisional application is what actually gets examined by a patent examiner, like myself and Gautam, and it gets published 18 months from the earliest filing date, and there are statutory requirements that must be fulfilled for what gets filed. Now, it's important to note that in order for your non-provisional application to get the full benefit of your provisional application's earlier filing date, the provisional application must fully support whatever subject matter that is claimed in the non-provisional application. And with regards to the patent term is measured from the filing date of the subsequent non-provisional application. Now, I had mentioned earlier that provisional applications do not get examined by a patent examiner, so it will never result in a patent. So why file a provisional? A provisional application provides you with a 12-month window to decide whether or not you want to pursue a non-provisional application. It can give you time to investigate the market potential of your invention, which may contribute to your decision of whether or not you want to pursue a non-provisional application. And it provides time to obtain counsel if you would like to work with an attorney to file your non-provisional application. Now, when you're filing a provisional application, the law requires that the following must be present: a clear indication that the applicant is filing a provisional application, a fee, which can be found on the USPTO's website, a description of the invention, which enables someone to make and use the invention, and drawings if they're necessary to understand the invention. Now, that clear indication that you're filing a provisional application is provided by submitting a cover sheet of the provisional patent application. And that form is PTO/SB/16. And that's what's going to provide that clear indication that the applicant is filing a provisional form. And it includes information such as your inventor's name, the residence, title of the invention, the correspondence address, attorney information if applicable, and U.S. government interests if applicable. Now, a requirement of your provisional application is that it includes a description of the invention, which enables someone to make and use the invention. The written disclosure must meet the same requirements as a non-provisional application. So in a non-provisional application, the written disclosure must meet the requirements of 35 USC 112A, which essentially requires that the applicant provide a full, clear, and concise written description of the invention so as to enable any person in the art or that technology field to make and use the invention. Now we're going to get into the components of the non-provisional application. A non-provisional utility patent application must include a specification, including a description and at least one claim, drawings if they're necessary to understand your invention, an oath or a declaration, and the prescribed filing, search, and examination fees, which can be found on the USPTO's website. Now, the first link on this slide is an online filing guide that provides the basic information about how to file a utility patent application. And the second link will take you to a patent application information retrieval site where you can look up file wrapper images of published or patented applications. And this may be a helpful place for you to see real examples of the components of a utility non-provisional application. Now, in the next several slides, I'll be referring to specific sections of the NPEP, which you can take a look at to get more detailed information. The NPEP is the Manual of Patent Examining Procedure, and it sets forth all the laws and regulations that must be followed during examination of patent applications. And the full text of the NPEP can be found on the USPTO's website. So before we dive into the more specifics, I just wanted to do a quick anatomy of a patent. So here you're going to have the title of the patent, the title of your patent, the inventor's name. Here you have the prior art citations that were cited by the examiner during examination or provided by the applicant for the examiner to look at. The issue date of a patent is up here. the abstract, which is a short summary of the invention, and then if you have a drawing that's most representative of your invention will be seen here on the front page as well. Now there's also the written description and the claims, which are on the following pages, and we'll be getting into more detail about what components make up a specification and how to write claims. So now let's first take a look at the specification. The specification should provide a written description of the invention. So this means that it describes how to make and use the invention. It should be set forth in clear, full, concise, and exact terms to allow any person skilled in the art or that technology field of the invention to make and use the invention. The specification should include at least one specific embodiment, which is like one representative example of your invention. And it concludes with at least one claim, which must begin on a new page. Now, this slide lays out the formatting of the specification, which are discussed in NPEP section 608.01. The specification, including the abstract and the claims, must have lines that are 1.5 or double space in a single column of text. It must be written on only one side in portrait orientation. The page must be 8.5 by 11 inches, with margins of at least 3/4 inches, except for the left side margin, which must be at least 1 inch. The application pages must be numbered consecutively, starting with page 1, and the page numbers must be centrally located either above or below the text. And the specification must also be written in non-script font, preferably with a font size of 12. Now we're going to take a look at the specific sections that make up the specification. The specification includes a title of the invention, which should be short and specific. And some of the more common applicable sections include a background, which discusses the state of the art before your invention, a brief summary of your invention, a brief description of the drawings, which is a listing of all the figures by number with a brief statement of what each figure depicts, and a detailed description of the invention. On a separate sheet, you must also have at least one claim, and then on another separate sheet, you must have an abstract, which is one paragraph that is less than 150 words. And NPEP 608.01a discusses the arrangement of the application elements and lays out the order of the sections of the specification. Now, these are some of the less commonly used sections of the specification, and they're applicable only in certain applications. I do want to point out that a cross-reference to related applications should be included if you are filing, for example, a provisional application. So now we're going to get into a little more detail about the required and more common sections of the specification. So starting with the title of your invention, the title should be short and specific and be descriptive of the invention. You should think of the title as a quick description of your invention, and it should allow a reader to readily ascertain what your invention is. So you should try to avoid generic language such as system or method for. Now, the background of the invention section would be where you can describe at a high level the areas or fields that are pertinent to your invention. You can also describe the prior art that's related to your invention, such as what you know has been done before, problems that led you to come up with your invention, and descriptions of the prior art that you know about. Now, the brief summary of your invention section is where you would provide a high-level description of your invention and what it does. You should describe the problems you solve using your invention and describe what makes your invention unique or different. So this would be a section essentially where you flesh out that abstract that you wrote. Now, if you submit drawings with your application, your specification must also include a brief description of the drawing section. Now, if you have drawings, the section must be provided before your application is considered complete and released from the initial processing stage and docketed to an examiner. The brief description of the drawing section includes a listing of all the submitted figures and a brief statement of what each figure depicts. Now, the drawings are a required part of the disclosure of your invention only if they are required to understand the invention. All drawings necessary to understand the invention must be submitted with the initial filing of your application, as they will not be allowed to be introduced after the filing date. The drawings must show every feature of the claimed invention, and they must contain as many views as necessary to show and understand the invention. 37 CFR 1.84 sets forth the standards for drawings, and black and white drawings are normally required for utility and design applications, and color drawings are permitted in design applications. Color drawings may be accepted in utility applications, but only after a granting of a petition explaining why the color drawings are necessary. And more details about the drawing requirements can be found in NPEP 608.02. So these are the requirements for drawings. And again, drawings are only required if they're necessary to understand your invention. So black and white drawings are normally required, and the lines and numbers must be heavy enough to permit adequate reproduction. Each figure must be labeled, and reference characters should be used to denote specific components of the figures. Now, each reference character should be used consistently. No single reference character can be used for two different parts. Each reference character used in the drawings must be described in the description, specifically in the detailed description of the invention section, which we'll go over in a few slides from now. And you should also avoid using descriptive words in the figures. In the detailed description of the invention section, you'll have a chance to describe the figures in more descriptive words. So the abstract. The abstract must start on a separate sheet with the heading abstract. The abstract is a single paragraph in narrative form, and it must be 150 words or less, 1.5 or double space. The abstract should not be a repeat of the claims or the brief summary of the section, but rather the abstract should point out what is new in the technology, and it's written to enable the public to quickly determine the nature of the technical disclosure of your invention. NPEP section 608.01b, as in boy, discusses the requirements of the abstract. So now we're going to talk about the detailed description of the invention section. This is a very important part of the section. The application. So if we think of your patent claims as a fence that defines the legal boundaries of a physical property, the specification is where your materials to build that fence lies. And much of the material or potential material that you want to use to build your fence are going to be in this detailed description of the invention section of your specification. The detailed description of the invention section is where you explain your invention and process of making and using it in full, clear, concise, and exact terms. You want to focus on explaining the structures, the processes, or the compositions of your invention. And if you have drawings in your application, you want to refer to figures and explain the different parts of the figures by use of reference numerals shown in the figures. If you have any experimental data, this is also the section where you would discuss those in detail. And NPEP section 608.01g provides more information regarding the detailed description of the invention section. Now, the detailed description should provide clear support or antecedent basis for all terms that are used in the claims, so that the meaning of the claims in the terms may be ascertainable by reference to the description. This is more of an opinion or a suggestion, but it can be helpful to draft your claims first. So going back to that fence analogy where your claims are the fence and your specification is the bag of materials to build your fence, it may be easier to determine what materials you need to build your fence once you have a visual of what you want your fence to look like. So by drafting your claims first, you can decide on the terminology that you want to use, because the terminology that you use must be consistent throughout the specification. You can also figure out what terms need to be further defined or explained in more detail in the specification. The claims can also serve as a checklist to make sure that the detailed description provides support for each element of the claims. You also want to keep in mind what direction you may want your claims to go in throughout the examination process. So, for example, if you want to amend your claims to overcome prior art rejections by adding new limitations to the claims, those limitations must have support in the specification. So, what that means is that those limitations must come from somewhere in your specification as originally filed. Now, again, this claims to specification order is just a suggestion and a matter of personal preference. You may find that it's more helpful for you to write your specification first, then derive your claims from that. But in all cases, this is an iterative process of going back and forth between the claims and the specification to iron out all the differences and ensure support, consistency, and antecedent basis between the two sections. I know we went through a lot, so we're just going to go review everything that we just talked about with regards to the specification components with some do's and don'ts. So, things that you should do. You should describe your invention clearly so that any person skilled in the art, which is that technology field, can make and use the invention without undue experimentation. If you have drawings in your specification, when referencing the drawings, be sure that each reference numeral is used only for one part depicted in the drawing and that it's used consistently, and that each reference numeral shown in the drawings is also mentioned in the specification. You should provide at least one specific embodiment, including the best one known to you at the time of filing. If you are submitting drawings with your application, and again, drawings are only necessary if they're necessary to understand your invention. You want to make sure that there is a brief description of the drawing section that includes each figure referenced by its full label. And if you're going to be using figure labels such as 1A, 1B, and 1C, they should each be individually mentioned and described and not collectively referred to as figure 1 in the brief description of the drawing section. You also want to make sure that there is proper antecedent basis for all the terms in the claims. And finally, you should focus on the technical features of your invention. Now, some things to watch out for when writing your specification. You should not use trademarks in the title or to describe the structure or use a mark that you intend to register for a commercialized product. So, for example, you should not use Velcro to describe a hook and loop fastener, but rather actually explicitly describe or recite a hook and loop fastener. The background of the invention section does not need to state how the inventor conceived the invention. So, for example, you do not need to state that you came up with the idea while you were jogging. You should avoid making claims of possible future success. So, for example, um, statements such as this invention will sell and make millions, or that this invention will revolutionize the field. Sorry, excuse. Sorry about that. um, you should not include a do not include a detailed discussion of the figures or refer to the reference characters in the brief description of the drawing section. That should all go into the detailed description of the invention section. And also, finally, do not forget to proofread your specification to look for grammatical and typographical errors. Now, for some examples of specifications, you can do a patent search on your database of choice of patent applications in your inventions field to get a better idea of what terms or wording are generally used and what types of features are talked about in the specification to get you started. So now we're going to move on to the claims. It's important to remember that what is written in the claims must be described in the specification. So the claims essentially define the invention and define what aspects are legally enforceable. So they essentially encompass the legal boundaries of your invention. So a claim defines the invention, but must be supported in the specification. So what does that mean? It means that the terms and phrases that are used in the claims must find clear support or antecedent basis in the description so that the meanings of the meanings of the terms that are used in the claims are clearly understood by reference to the description. Now, this is a sample claim. So We'll go into more detail about what the parts of the claims are, but for as like a general reference, a chair is the preamble of the claim, which will essentially be describing what you are about to claim, what the actual invention is. Comprising is a transitional phrase which will indicate whether the claim is open or closed, which means open means that any unrecited elements are still able to be added and still be within the claim's boundaries, whereas a closed transitional phrase means it is limited to exactly what is written and nothing more. And the bullet points you see here is the body of the claims and essentially lays out the elements of what the claims are. Now, so what are some of the specific details about the form of a claim? You should start your claims on a separate sheet with the heading called Claim Listing, and the claim sentences should be 1.5 or double spaced. Each claim is a single sentence that begins with a capital letter and ends with a period. You can use commas or semicolons in each claim sentence to clearly claim or describe your invention and separate out the elements, but each claim must only have a single period. Now, keep in mind that there are additional fees required if you have more than 3 independent claims or have more than 20 total claims. You must number your claims consecutively in ascending order. So, for example, 1, 2, 3, and so forth. And the original numbering of the claims must be preserved throughout the prosecution. So, for example, if you originally filed claims 1, 2, and 3, and then you decide to rewrite claims 1, 2, and 3 completely, what you can do is cancel claims 1, 2, and 3, and then add claims 4, 5, and 6. What you shouldn't do is first cancel claims 1, 2, and 3, and then add again those 1, 2, and 3 claims 1, 2, and 3 back. Basically, once you cancel a claim, you cannot add those same claim numbers back. But you can add new claim numbers, which essentially with essentially the same claim language as the canceled claim. Now, some of the claim requirements. Again, a non-provisional application must have at least one claim, and the claim must particularly point out and distinctly define your invention. The claims are written in independent or dependent form, and there must be at least one independent claim. A dependent claim necessarily incorporates by reference all the limitations of the claim of the independent claim or the dependent claim that it refers to. So in other words, a dependent claim incorporates all of the elements of the independent claim for which it depends. A dependent claim must refer to a preceding claim so that the reader knows what the dependent claim is depending from, and the dependent claim must further limit the claimed invention. So in other words, the independent claim is going to be broader than a dependent claim. So if, for example, we have an independent claim that says it's a car, a dependent claim may further define what that car is by saying it's a car with 4 doors or a car with 2 doors, so that it's more narrow in scope than the independent claim. So how do you plan to write a claim that best reflects your invention? So drafting a claim is an art. So not only do you need to write a claim that is reflective of your invention, but also that protects your idea from being stolen by a quick workaround. So when a claim is too specific, it might not provide as much value because others can easily work around it. However, on the other hand, if the claim is too general or too broad, it might not be patentable because it's possible that your general claim might already be known in the field and encompass things that are already in the field. So you want to think about finding that balance between an invention that is too general or too broad and one that is too specific. So when you draft a claim, you should think about what are you trying to invent? Is your invention a tangible thing or a product like a composition of matter or an apparatus? Or is it a machine or an equipment or um, an equipment that's needed for a particular purpose? Or is your invention a method of making the tangible product or using that tangible product? If you're claiming a tangible product, you should claim the components or the pieces that compose the invention and how they're interrelated. You are allowed to claim multiple inventions. So one independent claim may be directed to a composition, whereas another independent claim in that same claim set may be directed to a method of using or method of making that composition. You should also try to think strategically. Think about what goals you want to accomplish. Do you want to obtain the broadest valid claim? Do you want to obtain claims with a variety of types and scope in one application filing? Keep in mind that your goals could change, so the strategy might also change with it. So, for example, maybe at the time of filing, you have a different goal, but during prosecution, after seeing what prior art or has been cited by the patent examiner, you might want to adjust your goal or strategy because what you claim might not be patentable based on the prior art that's been cited. So you may, for example, want to adjust your fence to make it smaller and more narrow. You might also want to consider your budget. You are allowed to file 3 independent claims without an additional fee. However, additional fee um, and the fees can be found on the USPTO's website, but we do ask that you regularly check the USPTO website because it could be um, updated at any time. You are also allowed to file 20 claims without any additional fee. So the fees that are shown on this screen are for the micro entity, and to qualify as a micro entity, um, you must qualify as a small entity as defined by the USPTO, which is fewer than 500 employees. You must not be named as an inventor on more than 4 previously filed applications. And your gross income of the previous year from which the fee is paid must not be more than the maximum qualifying gross income. You must also not be under any obligation to assign, grant, or convey a license or other ownership interest to another entity that does not meet that same microentity status. So, in general, a claim should have 3 parts. So, the preamble, which is the introduction of what type of claim that you are about to recite. So, for example, it could be a method, an apparatus, or a composition. Um, Next, you will need a transitional phrase, which is generally comprising or consisting of. And we'll go into more detail about what that means in the next slide. And finally, a body that recites the elements of the invention. So it'll be the elements and how they're interrelated. So the transitional phrase, comprising versus consisting of. Now, what's the difference between these two? Comprising is an open ended phrase. So it does not exclude any unrecited elements or method steps. So if you have, for example, a car comprising 4 doors, even though it doesn't mention anything about an engine or steering wheel, it still encompasses all of those unrecited items and may include more. However, a consisting of transitional phrase is a closed statement and it excludes any elements or steps or ingredients that are not specifically recited in the claims. So, if we take that same car, for example, if you say a car consisting of 4 doors, it'll only be recited element. It can't include anything else that you have not recited explicitly. So taking this example of a shovel, the shovel would be the preamble. It introduces what that invention is. Comprising, which is the transitional phrase. Here, comprising is the open statement. So it indicates that anything that's in the body of the claims, it is not limited to that, but it can also include other additional unrecited elements. And then the handle and the blade having a point thereon, that's the body of the claim, which essentially lays out the elements that make up your shovel. And so now we're going to go into some do's and don'ts in claim drafting. So some do's. Look at you should look at your claims in the patent issued in your field. Um, as a guide or an example. So one way to do this may be by using your search engine of choice to look at some patent applications and patents that have been granted in your field to see how they draft claims. When writing the claim, you should particularly point out and distinctly claim the subject matter regarded as the invention. Consider drafting your claims first and then using the specification based on the terms that are used in the claims. You can review both claims and specification. You should review both claims and the specification to make necessary additions and corrections so that the claim terms find support in the specification and ensure that each term has proper antecedent basis and there's consistency throughout your application. You should also think about the legal protection you need for your invention and tailor your claim accordingly. And you should repeat this thought process to refine your claims and specification. So, things to watch out for when drafting your claims. Do not write your claims that cover two statutory classes of invention. So, you should not be combining a method and apparatus in one claim. Do not use terms inconsistently between the claims and specification. So, if, for example, you want to use the term visor, um, instead of having like three different versions of that word, use a single term consistently throughout the entire application. Do not write multi-sentence claims. Remember, each claim is only one sentence, but you can separate out elements of the claim for clarity using commas and semicolons. Do not refer back to only a portion of another claim in a further dependent claim. So, for example, you should not write the widget of the apparatus of claim 1. What you should do instead is write the apparatus of claim 1, wherein the widget is made of iron. And do not replace elements from another claim within a dependent claim. There should be consistency in the terms used throughout the specification and throughout the claims. So now we're going to go over some USPTO resources that may be of help to you while you are crafting your provisional or non-provisional application and going through the patent application process. So starting with the Inventors Assistance Center. The Inventors Assistance Center, or IAC, provides patent assistance and information to the public. The Inventors Assistance Center is staffed by former supervisory patent examiners and primary examiners who are available to answer questions and help make filing a patent application simple and efficient. So the Assistance Center can answer general questions regarding patent examination policy. They can answer questions concerning necessary formatting and items that are needed for your application. They can assist you with the forms needed and with filling out the forms. They can provide you with general information concerning patent examining rules, procedures, and drawings and fees. And they can send you information via and forms via email, USPS mail, or fax. Now, the Inventors Assistance Center provides you with useful information and non-legal patent advice. The Information Assistance Center cannot provide any opinion on whether the invention is patentable or not. They cannot conduct a patent search for you or any other intellectual property research. And they cannot provide a specific line-by-line completion of the form, but they can provide you with direction and guidance. Now, we also have the USPTO's Patent Pro Bono program, which is a nationwide network that assists financially under-resourced independent inventors and small businesses. In order to participate in the Patent Pro Bono program, the participant must have an income of 300% below the federal poverty guidelines, pay the USPTO filing fees and costs, demonstrate that they have knowledge of the patent system, which may be demonstrated, for example, by having a provisional application already filed with the USPTO or through completion of a certificate training program. You must also be able to describe the particular features of the invention and how it works. So essentially having the application pre-screened to ensure that there's more than just an idea. There is coverage in all 50 states, and this next slide will show you a map of this, which program covers which state. And this map can also be found on the USPTO's website. The USPTO's Law School Clinic certification program allows law students that are enrolled in participating law school clinic programs to practice before the USPTO under the guidance of a law school faculty clinic supervisor who is a barred attorney. So essentially, it's a win-win in that students get the chance to get real-world experience, and clients or the inventors get free legal assistance. So there are over 60 participating law school clinics that provide legal services pro bono to the public, and the list of schools can be found on the USPTO's website. Now, each participating law school has requirements for accepting new clients, and some service certain areas. Some only do patents or trademarks, some do both. So it's recommended that you look on the website and contact the specific clinic for a school that is able to work with you and able to serve your needs. Now, the Patent and Trademark Resource Center are a nationwide network of public, state, and academic libraries, and they're designated by the USPTO to disseminate patent and trademark information and to support the intellectual property needs of the public. You can find this map on the USPTO's website to see where the closest library is to you. And again, they provide resources such as access to the public search tool and can provide training and resources. And finally, here's a compiled list of links that may be helpful for you while you're going through this application process. And also, if you go onto the USPTO's events page, we have a list, we have free events that you can attend to get more information, educational experience, and yeah. So feel free to check those out and sign up for um, notification on when new training and events come out. Thank you so much for your attention. I know that was a lot, but if you have any questions, please feel free to reach out to us at Eastern Regional Outreach Office at uspto.gov.
Thank you so much, Monica. That was an amazing amount of information in a very short amount of time. We've had a few questions about whether or not there will be access to a recording and the slides. The answer is absolutely, because so much information. You definitely want the ability to come back and review this. So we will have the recording available along with a PDF copy of the slides. We'll send that out in a follow-up email in the next few days here. So I did want to bring up a few questions that have been asked, and Gautam has done an amazing job answering them in the Q&A box. And so if you do have any questions that you would like us to address now, please do pop those in the Q&A box at this time so we can make sure to get them answered for you. One question that I thought was an interesting one, and I would love to have you talk about it out loud, is, are patent attorneys generally recommended versus an inventor trying to file by themselves?
So a patent attorney or patent agent is not required to file a application. However, we do recommend that you at least think about working with a patent attorney, because this is a very involved and complicated process. And so, especially if this is your first time, if you have a complicated invention, we do advise working with an attorney to get you through that. It is a very involved process. So we don't want you to miss out on, getting the best protection possible for your invention. So that's why we recommend that we do that. And the USPTO's website has a database of patent attorneys and patent agents that are in good standing with the USPTO. You can search by location. And if you do decide to work with an attorney, we recommend that you do your due diligence to just make sure that you are working with an attorney who understands your invention, has a good rapport with you, has good communication with you. And a lot of patent attorneys and patent agents have their information online, like a biography uh, on their either the law firm's website or their own website, so you can see what their educational background is, what their experience is, so that you're working with somebody who understands your field and your invention.
Thank
And
you.
just
Yes, go
another
ahead,
thing to
Gautam.
add on to, I was going to add to that was if you also visit our USPTO.gov, there is a whole link on the right side. You'll see access to free resources. And if you click on that, you should be able to filter, patent attorneys related to, doing patents, utility patents or trademarks. So you can, it's a great resource. You should be able to check that out too. And if you want, I can put that link in here so you guys can in the chat.
That would
and
be
you can
wonderful.
follow
Thank
that.
you.
And I will also pop in the chat the database, searchable database for patent practitioners.
Fantastic. Thank you. So another interesting question that was brought up was in relation to an invention that is an app and what the quote unquote drawings would be for that invention. So I know Gautam, you had a great response there. And like I said, I just want to do some of these out loud to make sure we capture them in the recording to help others. So if you want to go ahead and talk about that, Gautam, that would be great. Let's see. Oh, we lost him. Hang on. Hopefully he'll come back.
I guess, so I guess
Go ahead, Monica.
I'll start off
While we
real
wait.
quick. Yeah, so I am in the chemistry field, so I'm not 100% certain on this, but with apps, maybe it could be like the user interface, like, what the screen looks like and just components of it. But again, drawings are really only necessary if they're necessary to understand your invention. So not all applications will have drawings, but it looks like Gotham's back online. So
Yeah.
Yeah,
you may.
my Zoom just crashed, so I had to. But yeah, I think Monica, I heard you a little bit. You're right. Drawings are definitely helpful, but flowcharts and visuals, as I mentioned in the chat, is a great way. But yeah, that gives an examiner to understand that really do you have something that you are trying to claim, right? Because the more you give, it's better for us as an examiner to really validate what you're trying to do.
And you can do you could do a quick search of patents in your technological field. So if you are trying to, patent an application, patent an app, you can maybe do a patent search on those kind of apps to see what kind of drawings are provided in those types of applications to kind of get you going in the train of thought of what to keep in mind.
Excellent. That makes sense. We had another question that was about what you can do around testing and such, public access to something before all of these filings go through. So Gautam, I would love to have you talk about what you put there in the Q&A box as well. Oh, let's see, you're muted still, Gautam.
So I think what I mentioned was it completely depends, right? You that's why this the provisional application is so helpful, because if you think that you have a, let's say, presentation tomorrow that you wanted to attract some investors or whatever, so it's better to do a prior filing with just provisional, and provisional really takes you could do it yourself. It's that easy. And you get a filing date, and then you go do your presentation next day, because now that cannot be used against you. So it depends, right? Again, that's why we highly recommend inventors, small businesses to really go for provisional and then do any public presentations or exposure. And then you have a year's time to basically go and file for non-provisional, where you get the patent rights if you get allowed.
Excellent. Anything you wanted
And
to add
then-
on that, Monica?
Yeah, so a little bit to add on to, I think I see the question that you may be referring to. So if, for example, while you are doing your testing or you're kind of searching to see what's out there, you find something that is very related to your invention. So this is where the claims are very important of how you craft it. So you want to either craft around what's already known so that you're not imposing on what's already been publicly disclosed. But also before you file your application, you should also be doing a patent search yourself, or not even the patent search, just a search in general yourself to show the examiner what is out there already, and to also for your own knowledge of what is out there already. So when you're crafting your application, you're not kind of getting into what's already publicly disclosed. So that'll give you a way to craft your claims around what is already publicly disclosed. And this is essentially what patent examiners do as well. We do the search to see what's out there and help you kind of narrow or tailor your claim scope to be non-infringing of publicly disclosed information.
Thank you. We have a question from someone who does have a provisional utility patent. So this person is under the impression that they will need engineered drawings of their invention in order to file the non-provisional utility patent. And so do you have recommendations on how to get those engineered drawings? Any resources to share?
Ooh.
So that's a
Yeah.
good question. But I think there are a few options you could consider, I think. First, you could hire a professional draft person or a patent illustrator who specializes in creating this accurate, detailed technical drawings. Or another option is to kind of reach out to an engineering firm who, specializes in patent applications. And that's what I can think of my head right now. Hope that helps.
Yes, it is. It is a very specialized question. Did you have anything to add, Monica?
I don't think I have anything to add to that, but yeah, I think if you are working with an attorney, I think I would assume that they would take care of that.
Okay, hopefully, yes, they might have some recommendations there. Okay, so we have another question that's come in. So some patent attorneys like to prep the provisional in with all the details needed for the non-provisional for an easy transition before that first year is concluded. Do you think that this is helpful as examiners?
Ooh, yeah. So it'll be helpful for you in the sense that you want to get the earliest filing date possible. And so that's something that the provisional will help with. But in order to get benefit of that provisional application's filing date in your non-provisional application, everything that you put in the non-provisional must be from the provisional application. So making sure that your provisional application is as complete and clear as possible will help you get the benefit of that provisional application, as much benefit as possible when you actually file your non-provisional application.
Excellent. And we've had several thank yous come in for all of the information. So I want to convey those to you. And let's see. Okay. We have first a thank you for taking the time to explain all of this. So this person's question is, can you have an awesome rest of your Thursday? Absolutely.
Oh, thank you so much.
Thank you.
I really
All
appreciate
right. So I think that concludes any of the questions that we have at this time. And I'm just taking a look through here. Yeah. So thank you so much to Monica and to Gautam. We are grateful for all of this, like people have said, so much information and going through and explaining it in detail. It's wonderful to have somebody explain it rather than just try and read it and imagine what that might mean. It is very, very helpful to have somebody go through and explain it. So we really, really appreciate you both. And thank you to everyone who has attended today. Some great questions. We appreciate those so much. And we do have a survey that will display when we shut the webinar down. If you're able to take a moment, we'd love getting your feedback. And so I'll turn it here over to Monica and Gautam for any parting words of advice, help, etc., that you would like to share.
Well,
Yeah.
I was just going to add to was if you, right now after the presentation, if some questions arise after this session, you're most welcome to email us at Eastern Regional Outreach Office at uspto.gov. I think I'll put it into the chat, the email address, and you can always ask the questions, and we could get your question answers that way too.
Excellent. I will pop that into that follow-up email that people will receive along with the recording and the slides so that they know exactly where to go to ask their questions. Monica.
Awesome. Well, thank you so much for having us. I mean, I think that's all I had to add. Echoing Gautam's words, if you have any questions or like a follow-up, please feel free to reach out to us. I put the email in the chat, and Jenny will also be sending it out. But thank you so much for your attention and having us.
All right. Have a lovely rest of your Thursday, everyone. And we hope to see you on an upcoming webinar soon. Bye-bye.